in the department, in the school, especially welcome. Now, just before I'm just introduce the judge to you, I was just thinking, and I mean, this is off script, so you know, I mean, Nani knows, but you know, we're living in a wonderful country, and we're passionate about our country, and we must get our students and our youth to stay here. And I mean, when we talk to them in class, you know, sometimes we say, and they say, but the mood's changing, because we need our youth to stay. They must be the future of tomorrow. Our students must become the Auditor Generals, the CEOs, the CFOs, etc. And that's a passion we share. And they can go overseas for a year and go and get world experience, but it's raining, it's cold in London, and why do you want to go there? Come back to this country. But we need also, and I don't want to call it the elders, because you're so young, but we need the wise ones to set the moral, to set that, and that compass for us. We don't need to set it, but we need the wise ones. And sorry, I'm totally off script, but just I was saying to you, we need a book. And I said to the doctor, we need another book. And Prof. Wiseman, Nkuglu, yesterday evening launched another book, and that book, he had a public lecture here, and that's why I'm making the link. And what's in that book is what came from the public lecture, but that's a message of values and doing the right thing and working together and making it work. So without pressure, I'm looking at the wise ones. Please, we need that direction because people look up to you. And thank you for also coming to the university and speaking to our students and setting direction, because we're creating the leaders of tomorrow with everybody here. So thank you very much. So that's off script, but please, no pressure. But we'll launch those books. We'll celebrate that success, but we need to do it. Then it's my privilege and honor to introduce to you Judge Boissie Mbha. Judge Mbha is a distinguished legal professional, a proud alumnus of the University of Johannesburg. Having earned his Masters of Law Tax degree in 2010, his academic journey includes an LLB from the University of Witwatersrand. We all know that against him. We close. But luckily, he's now alumnus of, like Prof. Mpedi always says, the great University of Johannesburg. Having earned his Masters of Law degree in 2010, I said Witwatersrand, he did labor law, tax practice, and military law qualifications there. In recognition of its outstanding contributions to the legal field and society, Judge Mbha was honored with the prestigious 2016 Alumni Dignitas Award by the University of Johannesburg. Judge Mbha has held several key positions throughout his career. We all know how renowned he is, including his current role as a permanent judge of the appeal at the Supreme Court of Appeal. He also served as an acting judge at the Constitutional High Court in Pretoria and Johannesburg. He's a leader in the legal and sport fields, and he has also demonstrated commitment, the highest commitment to ethical governance and accountability throughout his career. Judge, I can go on for very long, but we're looking forward to hearing to you. We want to give you more time and for questions. It's an absolute honor welcoming you, and thank you very much.
As the judge makes his way to the podium, may I please ask, excuse me, all our esteemed guests to put your phones on silent, just so we don't disturb the judge as he's speaking. Is the aircon fine now? Yeah. Perfect. Thank you so much. Judge, over to you.
Good morning to you all. It feels like I'm back home. My first association with this great institution goes back in the 1990s, early 1990s, when I enrolled for the higher diploma in labor law. Thereafter, as the practice, at the time I was practicing as an attorney, I started developing an interest in tax law, which necessitated that I further my knowledge in that field. I had done tax as a module whilst doing LLB at Wits, but then somehow I was attracted to the diploma program that was being offered by this university. Despite some persuasion from Wits, I opted to come to the University of Johannesburg. They didn't stop there. I came to the bench in 2003. And what happened was that the judge president, the then judge president Ngwepe, because I had this higher diploma in tax, he decided to throw me into the tax court. And then that spurred me on to enroll for a master's in tax whilst I was still on the bench. And I'm happy to see that my supervisor is here, Professor Kathleen van der Linde. I'm passionate about this university. I've had a great relationship with the Faculty of Law. I've given a few lectures whilst the current VC was the executive dean of the Faculty of Law. I'm happy to see that in the audience there are some faces that I know. Professor Litete is a great friend of mine. We've known each other when she gave her inaugural address after her appointment as professor. I see in the audience there are a couple of runners. I'm a marathon runner, by the way. It's the professor here is also a marathon, comrades marathon. Could you please, all the runners, 1D, and yeah, anyway, thanks. I'll go by the protocol that has already been established. The lecture today, I'm going to break it into about 4 segments. I think to give context to constitutional democracy, one must go back to what it actually replaced. I think in that sense, one will have a better understanding of what constitutional democracy entails. So I'll go back to the period prior, then delve into constitutional democracy, explain what it entails, all its ethos. Then I'll get into how the judiciary sees its role, and lastly and most importantly, how the accounting profession sees its role and must see its role. So the first question I pose is, where do we come from? The journey from parliamentary sovereignty to constitutional democracy in South Africa. In 1994, we began the transition from a system of parliamentary sovereignty to constitutional democracy with the coming into effect of the interim constitution of 1993. This interim constitution was later replaced by the final constitution of 1996. There is a stark contrast between these two systems of governance, especially if one has to be concerned with the dangers, I emphasize dangers, of unlimited and unconstrained legislative power. Under the previous parliamentary sovereignty system, Parliament had traditionally held the highest level of authority. It enacted laws that were considered supreme and could not be challenged. During this apartheid era, Parliament passed discriminatory legislation that enforced racial segregation and denied black people the ability to vote. The system was thus characterized by the absolute authority of Parliament. There were no effective checks and balances on Parliament's power to make, amend, or repeal laws. This created a potential for abuse of power, especially when combined with the absence of judicial review. What do I mean by judicial review? It means that the courts are enabled to question and challenge acts passed by Parliament which are unfair, racial, prejudicial, and so forth. I'll refer to some case study to show how Parliament abused its powers under the system of parliamentary sovereignty. There was a celebrated case in 1937 of Ndlwana versus Hofmeyer. Hofmeyer was the then Prime Minister of South Africa. What had happened was that Parliament, the Apartheid Parliament, had passed the Representation of Natives Act, number 12 of 1936. This act sought to remove so-called natives from the common voters' roll. At that time, black people had a limited right to vote only in the Cape Colony. And this act sought to remove that right. Ndlwana brought an action to challenge the validity of that act, and the court held that, no, we don't have the power to challenge or question the validity of any act that was passed by Parliament. So that act went through, and the blacks lost the limited right which they had to vote. That vote was only confined to the Cape Province. Then in 1952, we had a constitutional crisis when colored men, not colored people, colored men, their right was taken away. The then Parliament passed what is called the Separate Representation of Voters Act, number 46 of 1951. The then Appellate Division, the Supreme Court of Appeal, the court, my court where I was, is the successor of the Appellate Division. It held that in passing this act, Parliament had not followed the correct procedure. So the court could only question the validity of an act if at all a correct procedure had not been followed. But on substance, the court could do nothing. So what then happened was that the Nationalist Party so the court succeeded in declaring that act invalid, but only on procedural grounds. But then what Parliament did was to increase the number of senators, okay? They increased the number of senators, and by so doing, they were able to get the requisite majority, and then that act went through. Then all the colored men were removed from the common voters' roll. Something interesting about this case was that in the milieu of what was happening, Parliament then passed what was called the High Court of Parliament Act. Very funny act. Its aim, in terms of this act, Parliament could constitute itself to sit as a court. That's why it was called the High Court of Parliament Act. And the aim of the act, it's actually laughable. The Parliament could sit as a court, and it could declare judgments by the Appellate Division to be invalid. it had the power. It was it had the sovereign power. Now, the history of apartheid in South Africa offers a stark example of how parliamentary sovereignty was used to create and maintain a system of oppression. The white minority government used its unchecked and unlimited legislative power to enact a vast body of discriminatory laws. I cite a few examples and their harsh effects. There was the Natives Urban Areas Act 21 of 1923 and the Black Urban Areas Consolidation Act 25 of 1945. These acts restricted the movement of black South Africans into urban areas and enforced a system of influx control, limiting their access to jobs and housing in such areas. Blacks were required to carry a pass. There was Section 10 of this act. In terms of which, to be in an urban area, you were required to obtain a permit. You're required to carry a permit. I remember I passed matric in 1972. And in 1973, I started working. My first job was at a company called Hop, Keck and Doves, opposite Wits University. And I stayed in Pimville location, and I used the train. As you got out of Bramfontein Station, there would be a police raid. And I remember on 2 occasions, actually, I didn't have my pass, and there was a raid. Then they would say, "Monna Arbonne," let's say, and you had to produce a pass. And if at all you had not had a stamp that you had a Section 10(1)A, you'd be arrested and locked in. On 2 occasions, I was locked in at what was called number 4, where the Constitutional Court is. It used to be a prison. And where the court is, the court actually is built on the women's section of that prison. It was called number 4. It was funny when I went to act, when I was invited to act at the Constitutional Court in 2016. And I actually went to look at the cell where I was. Unfortunately, I could not locate it. Yeah. There's also the Group Areas Act 41 of 1950. This act enforced residential segregation by assigning different racial groups to specific areas. It resulted in forced removals and the displacement of millions of black South Africans. Sure, most of you must be aware of the effects of that. People were moved from one area would be declared that this is a white area, and then people would be just uprooted and dumped elsewhere. The Population Registration Act, number 30 of 1950, which classified all South Africans by race and was one of the foundations of apartheid's system of racial segregation. It dictated where people could live, work, and go to school. Then the horror of all horrors, the Bantu Education Act, 47 of 1953. It created a separate and inferior education system for black South Africans designed to limit their opportunities and prepare them for subservient roles in society. Most of you, or some of you at least, will be aware of what Dr. Verwoerd said when this act was passed. He said, black people, I don't want to use the word that he used, it's so painful to describe us, the K word. He said, these people are only fit to be hewers of wood, nothing else. The Terrorism Act, 83 of 1967, allowing detentions without trial while banning political activities and parties such as the ANC, PAC, SACP, etc. Various internal security acts, Section 6 of that act, making it easier to declare states of emergency, unlawful detentions, police use of force, etc. People died detentions, Steve Biko, Mapetla, so many, I mean, yeah. So all these laws restricted fundamental freedoms of black South Africans in almost every sphere of life, including freedom of movement, residence, work, and association. They also denied black South Africans the right to vote and participate in the political process, effectively silencing their voices and enabling the white minority government to maintain its grip on power. These injustices I've referred to were possible because there were no constitutional constraints on the power of parliament. Courts could not strike down these laws, however unjust, as long as they were passed according to the prescribed parliamentary procedures. The lack of a Bill of Rights meant that fundamental freedoms were not legally protected and were vulnerable to infringement by the legislature. Now, ladies and gentlemen, that is the first phase. I've given you just a taste of what life was under parliamentary sovereignty. Following the multi-party negotiations in the early 1990s, the interim constitution of 1993 was adopted, which then set the foundation for the 1994 elections. This 1994 election marked the beginning of the transition to constitutional democracy as enshrined in the final 1996 constitution, as I mentioned earlier. This resulted in a fundamental shift in South Africa's legal and political landscape. South Africa's constitutional democracy is now a system of government where the exercise of power is both constrained and enabled by a constitution that establishes the basic framework for governance and protects fundamental human rights. What are the core tenets of South Africa's constitutional democracy? It is the main characteristics. Firstly, constitutional supremacy. The Constitution provides that it is the supreme law of the land. All laws and conduct inconsistent with it are invalid, and its obligations must be fulfilled. Importantly, the courts have a duty to ensure that all branches of government operate within the bounds of the Constitution and fulfill their obligations as set out therein. This principle, that is of constitutional supremacy, thus ensures that the government's power is limited and that it operates within a framework of legally defined constraints. I refer to the case of Doctors for Life International versus the Speaker of the National Assembly and others, where the Constitutional Court had to decide whether the National Council of Provinces, NCOP, had fulfilled its constitutional duty to facilitate public participation in passing the Choice on Termination of Pregnancy Amendment Act and Traditional Health Practitioners Act. The Constitutional Court struck down these acts and declared them unconstitutional and invalid on the basis that the NCOP had failed to hold sufficient public hearings. In this case, the court emphasized the supremacy of the Constitution by referencing Section 2, which states that the Constitution is the supreme law of the Republic, and highlighting its obligation to declare a law invalid if it finds it to be inconsistent with the Constitution. In comparing constitutional democracy to parliamentary sovereignty, Ngobo J, who later became CJ, said the following at paragraphs 36 to 38. But under our constitutional democracy, the Constitution is the supreme law. It is binding on all branches of government and no less on Parliament. When it exercises its legislative authority, Parliament must act in accordance with and within the limits of the Constitution, and the supremacy of the Constitution requires that the obligations imposed by it must be fulfilled. Courts are required by the Constitution to ensure that all branches of government act within the law and fulfill their constitutional obligations. He went on to state that, I quote, "The Constitutional Court has been given the responsibility of being the ultimate guardian of the Constitution and its values. So that's the first tenet of constitutional democracy. The second important one is the separation of powers doctrine. The Constitution structures the government into three branches: the legislature, executive, and judiciary, with each having distinct powers and responsibility. This division aims to prevent the concentration of power in any one branch and promotes a system of checks and balances. The next tenet, important characteristic, is the protection of fundamental rights. The Bill of Rights in the Constitution enshrines the fundamental rights of all people in the country. These rights include, but are not limited to, equality before the law, freedom of expression, political and socio-economic rights, and access to courts. The next one, important one, is accountability. In a constitutional democracy, the government is accountable to the people. This accountability manifests itself in multiple ways. Firstly, through regular, free, and fair elections where citizens choose their representatives. Secondly, the Constitution emphasizes multi-party system to ensure accountability, responsiveness, and openness in government. The transition to constitutional democracy sought to prevent a repetition of the abuses that I spoke about earlier that occurred under parliamentary sovereignty by placing limits on legislative power and empowering courts to strike down unconstitutional laws and conduct. The Constitution seeks to ensure the protection of fundamental rights and the establishment of a just and equitable society. Now we get to the real issue. How has our judiciary performed over the last 30 years? We've already highlighted, and Professor Marx hit the nail on the head. At some point, I thought you had had sight of my speech because you really spoke about the important things that I'm going to highlight. The judiciary, as the guardian of constitutional democracy in South Africa. As I've said previously, in a constitutional democracy, the Constitution stands as the supreme law on the land. This means that any law or conduct that conflicts with the Constitution is invalid, and all government branches must fulfill their obligations as outlined in it. What are the key aspects of the judiciary's role? The functions of the judiciary, constitutionally. There are three in the main. Firstly, and importantly, judicial review. This means that the courts are vested with the power to review laws and government actions for compliance with the Constitution. This power enables the judiciary to declare laws or conduct inconsistent with the Constitution to be invalid. In terms of Section 172 of the Constitution, once law or conduct has been declared invalid, courts may make any order which is just and equitable. That's the first, judicial review. Secondly, the court's role is to interpret the law, interpret the Constitution. I'll give an example. Section 11 in the Constitution guarantees the right to life. The right to life. And the Constitutional Court had occasion to interpret what that right means. Hence, we had the Makwanyane case, State versus Makwanyana. The citation, for those who might be interested, it's CCT 3/94. And the court, in interpreting this right, said capital punishment, it is the death penalty, was inconsistent with the commitment to human rights expressed in the Constitution. So, you see, the duty to interpret the law. And thirdly, also most importantly, it's balancing judicial power with respect for the other branches of the state, namely the executive and the legislature. Earlier, I spoke of the separation of powers. So these important functions require that judicial officers, it requires that judges in particular, must uphold the highest ethical standards. And in this context, these ethical standards are encapsulated in the Judicial Code of Conduct, which is contained in the Judicial Services Commission Act, number 9 of 1994. I decided to place emphasis on this because it's going to be at the core of my talk when I talk about the role of the accountancy profession in protecting our democracy. So what are the ethical principles guiding the South African judiciary? We need an ethical judiciary because they've got a very important role to play. These ethical principles are deeply rooted in the Constitution. Section 174(1) of the Constitution states, and I quote, "An appropriate qualified woman or man who is a fit and proper person may be appointed as a judicial officer." I emphasize fit and proper. When we get to talk, when we get to talk about the auditors and that, the standard set here, there's reference, strict reference to fit and proper person. The Code of Judicial Conduct highlights the following principles for the South African judiciary: supremacy of the Constitution, rule of law. Judges are subject only to the Constitution and the law, which they must apply fearlessly and impartially. Protection of human rights. Oath of office. Upon their appointment, judges take an oath of office which obligates them to administer justice to all persons alike, without any fear, favor, or prejudice. Judicial independence. It requires judges to maintain an independent mind and resist any interference from the executive, legislature, or any other interest groups. This reinforces the principle of separation of powers, ensuring that the judiciary remains free from undue influence by other branches of the law. Judicial accountability, integrity. Judges must conduct themselves in a manner that maintains public confidence in the judiciary. Propriety. I check my Wikipedia. It says propriety is conformity to conventionally accepted standards of behavior or morals. You don't want to see your judges jiving in a tavern or you can do that privately. Equality, competence and diligence. You can have 100 cases coming to the court. And it's not a question of, hey, this person has lost all 99 cases. At least this one, let him or her, let's rule in the favor. It doesn't work like that. If 100 cases are bad, they must all be dismissed. If 100 cases are good and in accordance with the law, they must be granted the orders. Okay. All these principles taken together are the comprehensive framework for ethical conduct within the South African judiciary. They are aimed at ensuring that judges uphold the values of the Constitution, maintain public confidence in the judicial system, and administer justice fairly and impartially. I will now examine a few landmark cases which illustrate the judiciary's critical role in upholding the supremacy of the Constitution and thus safeguarding our constitutional democracy. I refer to the case of Grootboom, Government of the Republic of South Africa versus Grootboom 2000, where the court affirmed the people's right of access to adequate housing guaranteed in Section 26 of the Constitution. The court acknowledged that the state's obligation to fulfill socio-economic rights is subject to progressive realization, meaning that the state must take steps towards full realization of such rights within available resources. Importantly, the court stressed that measures adopted by the state must consider the needs of the most vulnerable, that is, those whose rights are most in peril. The state cannot ignore those in desperate need, and even while working towards the long-term goal of providing adequate housing for all. Whilst this is laudable, sadly, I must mention, is that Mrs. Grootboom, I discovered that she died in August 2008, and she was still homeless and penniless. One hears talk, it is popular, that this constitution is not worth the paper it's written on. In fact, I've even heard some politicians saying, we have to go back to parliamentary sovereignty. But it's not the constitution that fails. We must interrogate, why is it failing? Why is it we still have homeless people? That's the challenge that we must face. Healthcare. Minister of Health versus Treatment Action Campaign. The court addressed the right of access to healthcare services, specifically concerning the prevention of mother-to-child transmission of HIV. The court found that the government's policy of restricting the availability of nevirapine to a limited number of test sites was unreasonable and violated the right of access to healthcare services, which is guaranteed in Section 27 of the Constitution. In addition, the court highlighted the rights of children to basic healthcare services, emphasizing that the state's obligations extended to ensuring the health and well-being of its youngest citizens. Lastly, I refer to the right to basic education in MEC for Education in Gauteng Province and others versus the governing body of Rivonia Primary School and others. The Constitutional Court dealt with the right to basic education that is guaranteed in Section 29 of the Constitution. Here there was a dispute between a school governing body and the Provincial Education Department over the admission policy of a school that had been determined by the school governing body. The court held that while school governing bodies have the power to determine admission policies, this power must be exercised within the broader framework of ensuring access to basic education for all. Let me digress a little to tell you about this case. This case first came before the Johannesburg High Court. This child was from Soweto. The family lived in Soweto. And they wanted to enroll this child in the school. And the governing the governing body of the school had ruled that the teacher ratio score, the teacher-pupil ratio would be 1 to 24. 1 to 24. And so the principal said, look, this is against the policy of the governing body. This child cannot be enrolled. The mother went to court, challenging this. The provincial government, the MEC for Education, intervened as an interested party. yours truly was presiding in the case. I ruled, in fact, the court ruled in favor of the child, upholding the right of the child to education. This was in 2011. 2011. Just after the graduation, I just got my master's here. So, anyway, yeah, and the school appealed to the Supreme Court of Appeal, and the matter was enrolled at beginning of 2012, Supreme Court of Appeal. And in that year, I applied, Professor Kathleen, Professor here would tell you, I applied to do a PhD. And my supervisor was going to be Professor Lehuaila. Professor Lehuaila. And I came here, he interviewed me, and we spoke and all that. And just before I started with my PhD, I got invited to come and act at the Supreme Court of Appeal. Beginning of 2012. Off I went. I decided that, it's an elevation, it's important, career development. So off I went to the appeal court in Bloemfontein. When I got there, the first time, I looked at the roll, and I saw, hey, this case is enrolled to be here, to be heard. And I'm acting. And the matter was argued. It was argued, and the SCA set my judgment aside, and they said I was wrong. And that's how they interpreted it. And okay, I was so embarrassed when I went to the tea room. The SCA. Yeah, anyway. But then the MEC took the matter to the Constitutional Court, and the Constitutional Court set aside the SCA and said I was right. You can imagine when I went to the tea room. Anyway. Yeah, so, that's that. There are other specific instances where the courts took bold, direct steps to protect and enhance our constitutional democracy. A good example is found in the case of economic freedom fighters, the EFF versus Speaker of the National Assembly and others, Democratic Alliance versus Speaker of the National Assembly and others, where the Constitutional Court held that the remedial action recommended by the public protector following an investigation is binding. In this case, the then public protector, Advocate Chulima Tonsela, had investigated security upgrades at the then President Zuma's private homestead at Nkandla. She had found that some of these upgrades were not security related and recommended that he pay back money spent on them. So in other words, the Constitutional Court strengthened the hand of the public protector, an important office in our constitutional setup. The second example showing steps taken by the judiciary to protect our constitutional democracy can be found in the case of President of the Republic of South Africa versus Office of the Public Protector and others, a case which came before the Concord in 2017. In this case, the court accepted what it referred to as the binding recommendation by the public protector that then President Zuma appointed Judicial Commission of Inquiry into state capture to be headed by a judge selected by the Chief Justice. This inquiry was headed by then Deputy Chief Justice Zondo and lasted for about 4 years. The inquiry revealed massive corruption within government and the private sector, resulting in the theft and loss of billions of rands, monies which should have been utilized for the betterment of the citizens generally. In particular, this inquiry exposed massive corruption and capture of SOEs, state-owned enterprises such as SAA, ESCOM, SABC, Transnet, Denel, and others. Key state departments and functionaries like the SAPS, I beg your pardon, NPA, Intelligence Services, SARS, etc. These were all captured. In the course of that inquiry, various people, including ministers, politicians generally, and private professional people like lawyers, auditors, and accountants were implicated. And in the end, the commission recommended remedial actions, including but not limited to criminal prosecutions and referrals of some of the implicated persons to their relevant professional bodies. I'll come back to this point in a moment. In my view, this judicial intervention prevented a slide to anarchy. I wonder had it not been arrested, where our country would be at this moment. I've highlighted the role played by the judiciary, how it protected our constitutional democracy by upholding constitutional values. However, these gains have not been without problems. Currently, the judiciary is facing various challenges, some of which have been lingering. These include backlogs. Court delays and backlogs have been increasing. I was reading an article the other day that in certain matters, if you apply for a date, a trial date now, your matter will only be enrolled in 2028. 2028. Legal fees. Access to justice in South Africa is expensive and simply unaffordable for the majority of our people. They can't vindicate their rights. There's been report after report looking into this issue, and to date, very little, in my view, has been done in making courts more accessible. Institutional judicial independence. Individually, judges, I'm satisfied they are quite, at least the majority, they are independent and they're doing their jobs impartially and fearlessly. However, at the institutional level, I think that's where challenges are. For over a decade, the South African judiciary has shown not to be yet fully independent of the executive. For example, the judiciary does not own its own court buildings. These belong to the Department of Public Works. However, despite these challenges, the judiciary has always done, in my view, what was required of it. And when it is time to stand up for what is right, it has done so, even when the issues involved are highly charged. I'm sure you've read in the papers, in the press, how politicians have charged at the judiciary. Some have even used terms like there's a judicial dictatorship. Right, I've dealt with the judiciary's role quite at length. I now turn to the last aspect of my address, the accountancy profession and its role in protecting our constitutional democracy. I consider a good starting point to be the Auditor General of South Africa. You see, the Deputy Auditor General is here, Mr. Chauke. This functionary is a crucial component of our country's constitutional structure, playing a vital role in ensuring transparency and accountability within the public sector. It is another Chapter 9 institution specially created to support and strengthen our constitutional democracy. The Constitution emphasizes the independence of the Auditor General, stating that this institution is subject only to the Constitution and the law, and must be impartial and must exercise the powers and perform the functions of its office without fear, favor, or prejudice. This independence is further reinforced by the Public Audit Act 25 of 2004 as amended, which mandates that no person or organ of state may interfere with the functioning of the Auditor General. The requirement of impartiality ensures that the Auditor General conducts audits and investigations objectively without any external influence or bias. The Auditor General's main functions are to audit and report on the accounts, financial statements, and financial management of national and provincial state departments and all municipalities and municipal entities. The Auditor General's role is not limited to auditing financial records. The Public Audit Act empowers the Auditor General to conduct performance audits to assess whether state entities, including municipalities, have used resources economically, efficiently, and effectively. Now, I'm sure no one will argue with me that municipalities are at the cold face of service delivery. In terms of their constitutional obligations, which are set out in Section 152 of the Constitution, they are responsible for providing essential public services, including water, electricity, waste disposal, public health, transportation, etc., which are at the heart of the rights of citizens as guaranteed in the Constitution. The Auditor General's report, for example, for 2022-2023 to Parliament, does not, however, make for happy reading. In relation to financial management, the Auditor General stated, I quote, "Our previous report highlighted various weaknesses in municipalities' financial management, including poor financial planning, inadequate financial controls, and unreliable financial reporting. We also highlighted the lack of careful spending and reduced revenue and funding, which combined with the poor financial management practices caused financial distress at municipalities." I studied the report. I spent some time looking at the report. The AG broke it into various provinces. And, you know, there are some municipalities in certain provinces even failed to present reports. They failed to present reports. In one province, I mean, it's broken down. You'll understand the language better here. Unqualified with no findings, that is clean audit. Very, very few. Unqualified with findings. Qualified. Adverse. Disclaimers. Outstanding. You know, goes on and on and on. Eastern Cape, Free State, Gauteng. Unqualified with no findings. 2021, 2022, there were two, only two. 2022, 2023, only one municipality. At least outstanding is 0-0, at least. I think they deserve some round of applause. You know, I'm mentioning this, I mean, if at all a municipality fails or omits to present an audit report for a year, what do the accountants, bookkeepers, accounting personnel, CFOs, I'm sure they were drawing their monthly salaries. The Auditor General reported further that there was little change in certain municipalities' financial health and financial management, as characterized by unfunded budgets and overspending, weaknesses in revenue management, financial losses, inadequate financial controls, and unreliable reporting. The question we must ask ourselves in this scenario is, where are our auditors and accountants? Did they discharge their duties and obligations in the manner expected? Earlier, when dealing with the role of the judiciary, I briefly dealt with the Judicial Commission of Inquiry into State Capture. The report is riddled with references to monstrous audit failures and deliberate and dishonest conduct on the part of various people who are qualified auditors, accountants, and financial managers, legal professionals, lawyers. The report highlights how various state-owned entities were characterized by weak financial controls, illicit financial flows, failure to uphold fiduciary duties, the enabling of executive overreach by following unlawful instructions, disguised payments, and general auditing failures. In the private sector, one also sees worrying trends of audit and accounting failures. Examples are African Bank, Linkway Trading, Steinhoff, Togat Hewlett, VBS Mutual Bank. All these behemoths had auditors and accountants looking after their books. The case of Steinhoff is particularly concerning in relation to the accounting profession as a whole. Evidence shows that there was financial misconduct committed in this company from 2014, culminating in the company's collapse in December 2017. The misconduct, in essence, consisted of a deliberate misrepresentation and fraud which centered on overstated earnings, inflated by approximately 100 billion rands through fictitious sales and inflated asset values. I mention Steinhoff precisely because it was a public company listed on the JSE, amongst other stock exchanges, and was thus obliged in terms of the Companies Act 71 of 2008 to publish audited annual financial statements. JSE rules, Section 30 of the Act. They require public company, a listed company, to publish annual financial statements. But then we see problems occurring from 2014 right through to 2017. So one asks oneself, but how could this have happened? One can clearly see a conspired collusion to act illicitly and of necessity involving professionals like auditors, accountants, CFOs, and the like. The case of VBS Bank in particular is one of a tragic, sad, and sordid tale of misery, where simple folk, mainly in Limpopo, lost their life savings, burial and Stokvel Society funds, and also certain municipalities that had illegally invested public funds therein. Again, the question that confronts one is how could such a loss of a couple of billions of people's monies get stolen or dissipated in the manner that it happened over a period of time in the face of clearly laid down governance procedures, including auditing and accounting processes. I do not have the slightest hesitation that anyone in this audience would disagree with me when I say that the greatest threats to our constitutional democracy, poverty, unemployment, youth unemployment, inequality, little or no economic growth, crime, corruption. The failure or collapse of our public institutions like municipalities and SOEs, as I've detailed above, with a concomitant failure of the private sector like Steinhoff, etc., unquestionably lead to the maladies I've just referred to. There is no question that these maladies can lead to instability in the country and can be a recipe for a failed state. I need to state clearly that there are lots of areas and cases where the accountancy profession has served us, the nation, very well and have protected the public interest and our constitutional democracy. We've got star performers. I mentioned a few. Professor Wiseman Nkulu, the first qualified black chartered accountant. My sister here, Ms. Nonkululeko Koboto, the first female black chartered accountant in South Africa. Ms. Gloria Serobe, a chartered accountant of high integrity and unquestionable professional ethic and commitment to serve the country. Ms. Tsakani Maluleke, the first female Auditor General produced by this country. Her predecessor, Mr. Kimi Makweti, may his soul rest in peace. Mr. Shoke Faki, the first Black Auditor General of democratic South Africa, and many others. These are all role models up to whom you, students, accounting students, you could look up to for guidance and examples of how best you can serve society and protect our democracy. When I spoke in relation to the judiciary's role, I alluded to the qualities of what constituted a fit and proper person to be a judge. Now I consider what are the qualities required to be a fit and proper accountancy professional, the auditor, financial accountant, whatever. The Independent Regulatory Board for Auditors, the IRBA, a statutory regulatory body established in terms of Section 3 of the Auditing Profession Act 26 of 2005, with its primary mandate being the regulation of auditors in South Africa, has adopted what it refers to as the fit and proper policy to provide the framework for the assessment and determination of fit and proper auditors. In terms of that policy, a fit and proper person is described as a person of integrity and good standing. Candidate and registered auditors must demonstrate the following characteristics: ethics, prescribed competencies, financial soundness, and capability. The IRBA has put together a code of professional conduct in terms of which 5 fundamentals of ethics are set out. These are integrity, to be straightforward and honest in all professional and business relationships, integrity, objectivity, professional competence and due care, confidentiality, and professional behavior. Significantly, the IRBA's regulatory strategy of 2021, which was in response to the audit failures referred to above, like in Steinhoff and the like, recognizes that, quote, stimulating economic growth requires confidence in the capital markets and in attracting increased foreign direct investment. Likewise, rebuilding confidence locally will unlock private sector investment. Improving investor sentiment is key to how the IRBA can contribute to one of the core elements of the National Development Plan. So the IRBA, the regulatory body for auditors, recognizes the sterling important role to be played by auditors. Once our auditors do what is expected of them, investors will come in because the confidence will be boosted. If we are told we invest our monies in South Africa, our monies are safe. There's no chances that monies will be stolen or whatever. And this can only result in growth, economic growth, and which ties up, expressly stated by the IRBA, with the National Development Plan. As you're all aware, the NDP is an ambitious plan adopted by the government, which seeks to have uprooted poverty, to have increased our economy tremendously by 2030. The strategy further elaborates that the IRBA is committed to engaging with the audit profession locally and internationally to identify and rectify issues of poor audit quality, and that by restoring investor confidence in auditing and audit quality and rebuilding trust in the financial statements of public interest entities, it is possible for the IRBA to play its role in supporting government efforts to promote an economic recovery in line with the national public interest. With regard to the broader accountancy profession, unlike auditors, where one finds a statutory regulatory body like the IRBA, my research could not find a similar statutory equivalent. I'm subject to correction. You know the situation better, but my researcher, we couldn't find an equivalent regulation. It might be there, we might have missed it, but you know the situation better. I discovered that there's a global body, namely the International Federation of Accountants, IFAC, to which 2 South African voluntary accounting bodies are affiliated. I also discovered that there were roughly about 12 similar voluntary professional accounting organizations. You know, accountancy has got different sectors, so I take it these 12 refer to the different sectors. The 2 which are affiliated to IFAC, according to my research, are the South African Institute of Chartered Accountants, SAICA, and the South African Institute of Professional Accountants, SAIPA. In terms of SAIPA's code of conduct, this institute is committed to transparency and serving the best interests of the public to combat bribery, fraud, and corruption in the South African economy. The members of the institute have a professional obligation to report any non-compliance to laws and regulations, or should the need arise, to whistle-blow any fraudulent or corrupt activities that they are aware of, as per the International Ethics Standards Board for Accountants Handbook. This is the IESBA. The SAIPA Code of Conduct also prescribes that members of the institute should subscribe to the fundamental principles of integrity, objectivity, professional competence and due care, confidentiality, professional behavior, and independence. The second professional body affiliated to IFAC is the South African Institute of Chartered Accountants, SAICA, whose code of conduct also specifies the fundamental principles of integrity, objectivity, professional competence and due care, confidentiality, and professional behavior. In the course of my research, I came across the 2023 annual report of this body, and I saw that its disciplinary committee held quite a number of disciplinary inquiries during which members were subjected to various disciplinary sanctions. Prominent among these was that of one individual who I choose not to name, who in March 2023 was charged and convicted. Sadly, this is a lady, and but anyway, she was charged and convicted on 12 counts relating to various acts of misconduct, including illicit receipt of large amounts of money, misrepresentation relating to fees received by her firm, dishonesty, etc. All of these had its genesis in the findings and recommendations of the Judicial Commission of Inquiry into State Capture. I must state that I found this from the report, and that I have no knowledge whether, as of today, these convictions still stand or whether they might have been taken on appeal. I'm qualifying myself. I don't want to be sued for defamation. In all, we need an honest accounting profession that recognizes its critical and important role in protecting our constitutional democracy by preventing threats to it, like various acts of criminality, such as fraud, theft, money laundering, and unethical conduct. To our students, you've got role models you can look up to. Ethics is very crucial to the sustenance of our constitutional democracy. There's a huge role on your shoulders. I wish you good luck in your exams and the best in the future. Thank you.
Sure. I don't know if the aircon got extremely cold or was it the chilling words as the judge was speaking? How many accountants here suddenly thought, is the judge saying we are as important as the judiciary in protecting our constitutional democracy? Absolutely blown away by your words, Judge. I've come as I've grown. I'm not that old, but as I've grown to appreciate the saying that those who forget their history are bound to repeat it. And I loved how you put context to what our constitutional democracy is, how it came about, and why we need to protect it so jealously, and what our role is as accounting professionals. So thank you so much for that. I am sure we all appreciate it as accounting professionals, whether academics or acting in practice. So thank you very much for that. I am cognizant of the time, and initially we were going to grant 15 minutes for a question and answer session with the judge, but we'll cut that down to 10 minutes. So we'll still have an opportunity to ask him questions. When you do ask your questions of the judge, may I please ask that you state your name, who you are, and where you come from, your organization. I think let's do it in rounds of perhaps 2 people per round, just to give them an opportunity to remember all the questions and to answer them effectively or adequately. Are we all happy with that? Yes or no? I feel like I'm in class. I love hearing my students' answers, so thank you for answering me. But yes, please, by show of hands, let's take questions. Thank you. So that's one for our Deputy Auditor General and another one here. Yes, sir.
Good morning. Thanks a lot, Judge, for such a lovely presentation. Good morning, my boss. She will always be my boss. I started being a partner at Goboda, so I should always be my boss. Quick one. So firstly, thanks for the history. I think it's very good to just make us reflect as to where we're coming from. And sometimes we forget as to what it is that we're trying to do. After mentioning the AG so many times, it will not be good for me to first thank the judiciary for continuing to protect some of the things that I personally believe that while the aim was to give access to the courts, sometimes we tend to abuse the court system by taking matters that does not belong in the courts. And I do understand and appreciate that you may not kick things off the roll until you have spent your time dealing with it. And I think the story that you shared about the access to education indicate that it is important for this process to go through. There has been a current case that AGSA is dealing with a particular entity, which the intention was just to ensure that they don't account by not wanting to report properly. I'll not repeat that particular entity because the issue is not about that entity. It's the principle to say that we do need as judges to continue doing what you are doing to ensure that matters that which don't belong in the court, when they go there, you still continue to apply your principle. But the question, and not really for you, but for people to reflect, right? You spoke about the outcome of the Zondo Commission. Thanks to the former Chief Justice for such good work around it. And some of the key principles that came, or some of the key findings that came out of that was some of the roles of the professionals. And I'm glad that in this room there are a lot of professionals. And I'm trying to ask this question. I'll leave it to you to answer, but I do hope even the professionals are going to go and answer it themselves. The Chief Justice found that the modus operandi in the state capture, it was to weaken the boards by either bringing people with bad intentions who will then, for what the Judge King says, it's a person who can't do anything being a company or as a state-owned company, they'll make bad decisions on their behalf. You also mentioned the Steinhoff. And when you look into the Steinhoff board and you look at the people who were sitting in the boards around that time, is the A grade of any board member that will want in this place. And my question to you, but also to the general professionals here, especially the accountant, is what role must we play as individuals? Because I think the last one that you also mentioned, which Saika was dealing with, where a professional person who was in one of the state entities did not do their part. Because at the end of the day, it's really up to us to ensure that we remember your words that we must be fit and proper. I know you gave an example that we should not go and dance in the tavern, but I guess the important part is in our daily lives where we are entrusted because of our professional role. What do we do when we're sitting in these various positions of power? And because people trust us, and there are a number of few good South Africans who have really upheld the integrity of their professions, what do we as accountant and the judiciary as one of the oldest profession ensure that we get the country back online using the lessons learned from Steinhoff and also what's coming out of the Zondo Commission? Thank you, Judge.
Thank you very much, Judge, for that presentation or the lecture. It was very informative. My name is Olwetu Kwabe. I'm from McGerald's Entrepreneurship Center, but currently I'm a student at VETS. My question is on, so you spoke about the key aspects of the Judiciary Court, which is interpreting the Constitution, and then you mentioned the right to life, but one right that I would like to focus on is the right to education. And then what's happening currently is that you have institutions like VETS, UJ, having this law, I don't know if it's a law, but it's something that exists, which is called financial exclusion. You spoke about students being the future, but then the way it's going, it seems as if students won't have any future. Because my question is on that point, just NSFAS as a whole, now they enforce something called the financial cap, where they will pay 60% of the fees, but then 40% will remain with the students, which is the same case that I'm facing. And then what happens is the following year you're excluded. So I wanted to ask, which law protects the students against this act of just financial exclusion? Thank you.
Oluti is asking a very difficult question. I think let's look at it from various angles. I'm sure there's no one who can dispute or deny that the inception of NSFAS, the whole concept of NSFAS, was a very positive intervention in our lives. One can, I addressed students at Morris Isaacson High School, where I did my high school education, and they raised the same sort of question that you raised, and I said it's indisputable. The democracy has worked. There are positive actions, interventions that have been implemented. It's possible today, or in current times, for a student or a child, let's use a child, to start education from grade 0 right up to varsity without paying a cent. It's possible. There's no one who can deny that. We've got free fee paying schools in Soweto. Children get meals. My wife was a headmaster of a school, and I went there and I saw for myself. There are bursaries, and then there's NSFAS, things which were never there when I went to school, when I did go to. So there are positives. But now, you find problems coming up in implementation. That's where your problem is. That's where our problem is, implementation. I mean, NSFAS is a very good system. Financial exclusion, well, I think it goes to the core of the administration and policies of various institutions. And these are areas which need sorting out, sitting down and debating and finding the best way to resolve these issues. I think that's the best answer I can give. If there is any policy which is discriminatory, that can be challenged. But a policy must be seen to be fair and impartial, and it must be reasonable, it must be rational. So I think your question really turns on those aspects. Yeah. I don't think I can, unless there's anybody in the audience who wants to contribute. Yes. Deputy AG, Mr. Chauke, what can we do? What can we do? Let's get people of integrity into the professions that will solve our problem. The process starts even much earlier, at the appointment stage. I'm sure you've seen how judges are appointed. It's a rigorous process. People are subjected to interrogation and, so, yeah. But then I must concede that at times bad apples manage to filter through. And let's get people of integrity into the professions. Thank you.
Please don't be upset with me. We can fight outside afterwards. I'm looking at the time, and we really are running out of time. It's our fault putting lawyers, accountants, academics in a room and expecting them to keep to time and not discuss was an oversight on our part. I'm unfortunately going to have to stop the question and answer session. I'm hoping the judge, if you're still available afterwards, might remain for a while and engage with some of the people who may want to engage with you. Otherwise, we can perhaps try and put you in touch with the judge. But I'm sorry that we can't take any more questions. I'm going to ask now our Acting School of Director, Ms. Vanessa van Dijk, to please come up and give her closing remarks. Thank you.
Thank you very much. Thank you, Judge. I'm reminded of a quote by Nelson Mandela. Never, never, never again shall it be that this beautiful land will experience the oppression of one by another. And I can't help but think the background that you gave to how our democracy came to be just reminded us of that, and how incumbent it is on us to remember that we will never ever go back to where we came from. Because we cannot go forward and we cannot learn from the past unless we remember that. I think the core of today's talk speaks to what the School of Accounting, the Department of Commercial Accounting, and the University of Johannesburg stands for, and that is about ethics. You said it, Judge, we need to employ people with integrity, and there are many academics in the room today that I know at the heart of what they do every day is steeped in integrity and teaching students about doing it the right way. I don't think the importance of this can be emphasized enough, that we need to strive for ethical behavior, we need to uphold integrity, and that needs to be at the judicial, executive, and the accounting profession level. We can't do this on our own. Today's lecture, Judge, was not only informative and impactful, with a strong message for us to take away, but also so very engaging. I think my favorite parts were the personal stories that you shared about what you have gone through in your personal career. I'm reminded that the protection of our democracy is not anyone's responsibility, but everyone's. We have to be accountable to others, but most importantly, we have to be accountable to ourselves, whether we are in the accounting profession or whether we're an academic, a judge, or just a member of society. We have to rely on each facet of society to make our democracy work. We must be fearless in our pursuit of equal rights for all, and to safeguard that has been entrusted to us. I challenge each of us today to commit to the protection of our democracy, and I thank you, Judge, for reminding us about this. I think you are such a positive role model, and thank you for reminding us of others in our profession who stand strong in their ethics and in their integrity, and who we can look to when times are tough and dark. Please come back and finish that PhD. We invite you to the School of Accounting for that. And in Prof. Ben's words, please write that book too. Thank you very much.
Thank you very much, Vanessa. The last item for the day, I'd like to ask our Head of Department of Commercial Accounting, Ms. Budomela Kuzayo, to please come up for a vote of thanks.
Thank you so much, Mr. Kumalo. I greet you all in the name of integrity, accountability, and the constitutional democracy. Thank you so much, everyone, for coming today. My role is relatively easy, just to do thank yous. I was reflecting this morning about the relevance of the topic. At some point in time, I thought, is it necessarily relevant? Elections have taken place. And this week we're celebrating 100 days of the Government of National Unity, the GNU. And this morning I also was listening to the news, and there's 4 prominent people in our country who are currently in court for different misdemeanors. And I think when I reflected on that, considering that elections have passed, this topic is still very relevant in our country. I'd like to expand a bit on what my colleague Mr. Khumalo spoke about in terms of our department. We are from the Department of Commercial Accounting. Our home is in Soweto campus, so if you'd like to find us, that's where you can find us. We offer a flagship qualification, and some of our students and alumni are actually in the room today. So I'd just like to say thank you to the students who are here. I hope you've taken the wisdom from our great judge today in terms of the types of professions that you can be in our country, because the future is indeed in your hands and not necessarily in the judges. I would also like to mention, in terms of last week, the university and our VC launched the strategic plan for 2035. One of the key and fundamental pillars is social impact. I think our department is strategically placed in Soweto because we offer our qualification to students who come from what Judge was talking about, low fee paying schools or no fee paying schools. And the impact that we make to our students is quite big, because they typically come into our qualification or to our department not by choice, but we work to make sure that our department and our qualification is the qualification of choice. It's not by choice because they either did maths literacy in high school, not of their choice as well. They were encouraged to take maths literacy, not knowing the impact it would have if they want to further their education. Secondly, some of them don't have the required APS score to get into a degree or to pursue the chartered accountancy route. So when I joined the institution, and what has been a common story in terms of the staff that I work with, a lot of our students feel disengaged or disheartened. And as a department, we've worked to make sure that we speak to that social impact, give our students the hope that they need in order to say, you know, not everyone can be a chartered accountant, firstly. The accounting profession is quite broad in terms of the judge speaking about IFAC and the different professional bodies that exist and the streams that actually can be taken by people who want to remain within the accounting profession, whether it's taxation, management accounting, finance, auditing, everyone's favorite subject. So I think it's just good to give you context about who we are, and I think how fitting it is to have had the judge to join us today. He's born and bred from Soweto, Pimville, and maybe to speak to how I actually got to know him, I met him last year at the VC's inauguration. I had seen him, and I recognized him because we actually go to the same gym. I'm like, oh, there's a familiar face. I went to him and I said, hello, how are you? And because he didn't know me, his initial reaction was, who's this person? And he, by his nature, is an introvert. But I think what you've seen today is once he gets comfortable and he gets to talk about what he enjoys, he actually relaxes. So I met him at the gym again. I said, hi, Papa. I met you at the inauguration. Then he started asking me, firstly, what's your name? I said, no, I'm Bitumele. And typical to his generation, similar to my father, you have to introduce yourself by name and surname. So he said, so what's your surname? Utswahamang. And over the months, I've gotten the privilege to actually engage with him and to spend time with him. And I think that's why I thought today was quite fitting to bring him, especially with his taxation knowledge and the wisdom that he shares. Every time I have coffee with him, I sit there and I think I can't be the only one actually experiencing this. Despite his humility, he doesn't want people to know much about what he does. But thank you, Papa. And I think it also resonates, or it filters into his family. So a separate incident, beginning of the year, I received a phone call from 2 of our colleagues at the University of Johannesburg, Thabiso Madiba and Boniswa Madigizela. And they said there's someone who'd like to donate lamps to our third-year diploma in accounting students, specifically anyone who's studying at Soweto. And I got a call. The gentleman donated 150 lamps for students to complete their studies, as well as books. I found out a bit later on that that gentleman is actually Judge Mbha's nephew. So Tato says hello. He couldn't make it, but thank you so much, and continue paying it forward as a family. Something, well, I think also reflecting on how, as individuals, we shouldn't necessarily stick to our profession and be diverse individuals. It's good to see how balanced Judge Mbha is as well, and a few people in the room. He hasn't mentioned this, so he is a runner. He's run 11 comrades, and he started running in the latter part of his 50s. So there's this common saying that says, you know, every South African should do the comrades at least once. I think this should be more encouragement to say, try to do it at least twice. So thank you, Judge Mbha. Thank you for, I think you lead by example, and you also represent that as individuals we need to be whole and serve in different ways. And I think the fact that there's fellow runners in the room is a testament of how they experience you, and they want to get to know more about what you do and the impact that you make in their lives. So thank you so much. Taking it a bit further as well, so he also didn't mention this, but tomorrow he is on his way to his alma mater, Forte University, where he's going to be awarding he's attending an awards ceremony, and one of the awards is actually in his name. So continue to do the great work, and no pressure, rekopabuka. And then just to close, I'd like to thank our great MC, Mr. Lesego Khumalo. You were quite exceptional. I think as an audience we can agree to that. I'd like to thank the leadership team, Prof. Ben Marks, as well as Vanessa van Dijk. When I approached them with this idea, they didn't think twice. They supported it wholeheartedly, and I really appreciate it. Thank you so much. To the Department of Commercial Accounting and the staff that I work with, thank you so much for supporting this event as well, and the work that you do for our students. It is, my dad always jokes to say, we're not necessarily academics, but we're social workers. We make a big impact in people's lives. So thank you so much to my colleagues, as well as colleagues from the accountancy department. I'd also like to thank people who made this event possible. Like, I can't thank them enough. To the team that I work with, Nozizwe CBC, she's our marketing coordinator. To Mr. Lerato Tsukulu, he is our departmental secretary. To Temba Masango, our admin assistant in the department. To the team at UJTV, we reached out to them last week, Thursday, I think. And thank you so much to Hirsch and your team for really giving our function the full uplifting it. We really appreciate it. To the team at the UJ Ubuntu Chambers, thank you so much for accommodating us today and for hosting us. To our peer mentors who were our ushers today, leading everyone to get here to make sure you don't get lost at the great University of Johannesburg. Thank you so much for being here. And to everyone in the audience, when I was looking at the RSVP list, there's literally a diverse audience in the room. People from the legal fraternity, people from academia, people are running their own businesses. And it's good to see that such a topic can actually draw so many people. and it's really apt and fitting within our various domains, and it's something for us to move forward and to think about in terms of how do we contribute to our society. So with that said as well, I'd like to close by mentioning that in light with social impact, as well as what our VC speaks about regarding doubling the impact, our department for the past 2 years has been trying to raise funds for our students, deserving students. So every year they need to pay for a registration fee, back to what the gentleman was talking about here. As a department, we have taken it upon ourselves to do what we enjoy, whether it is running, cycling, hiking, or just walking. And we try to do some crowdfunding to get people to support our cause so that we can actually help our students return and worry less about what it is that they need to focus more on their education and worry less about the resources that they need in order to obtain their qualifications. So at the screen behind me is a QR code. We, as a department and friends of DCA, we call them, we have 2 initiatives that are coming up. The first one is Soweto Marathon. Our campus, the 42-kilometer runs past our campus. So we are hoping to have a few people from some of our staff, actually runners as well. We'll have supporters as well there with a marquee telling people no walking in running shoes to encourage them to keep going, as well as the 94.7 ride Joburg later on in November. I'll be participating in that. There's a few staff as well, including friends of DCA. So we'd like to encourage you to please donate if you can. Please select donate to commercial accounting. There's a few options there. Please select commercial accounting, and please help us double the impact and make a huge impact in our students' lives in order to reach what Judge Mbha was talking about in terms of the future that we look for within our country. I thank you so much. Please take an opportunity to go to the foyer that side. There's some few snacks as well, and an opportunity for everyone to network. To everyone who joined us on the live stream, thank you so much for taking the time to join us, and we'll also share the recording with everyone. Thank you, and enjoy the rest of your day. From the department,